This is Chris Reed.
Hello, Mr. Reed. This is the Child Support Court. Let me start with, is your client with you, or do I need to call her separately?
When we had agreed to call her separately, if you would, please, Your
That's
Honor.
fine. That's fine. We'll do that. Hold on.
Hello?
Hello, is this Miss Kellogg?
Who?
Is this Tara Kellogg?
No, you have the wrong number.
Oh, excuse us. We'll try again. Sorry.
Okay.
Man, I'm so sorry.
No worries.
One number off.
Hello?
Hello, is this Miss Kellogg?
Yes.
This is the Child Support Court. I got your lawyer on the phone. Hold on while I try to call Mr. Ghibaudo now.
Okay, thank you.
This is Alex.
Hello, is this Mr. Ghibaudo?
Yeah.
This is the Child Support Court. Hold on while I patch everybody together on the phone together.
Okay.
All right. Are you there, Miss Kellogg?
I am.
Are you there, Mr. Reed?
I am. Thank you, Your Honor.
And are you there, Mr. Ghibaudo?
I'm here.
Thank you. All right, so like I said, this is the Child Support Court calling the case of Kellogg versus Ghibaudo, case 161999. Starting with you, Miss Kellogg, will you state your name for the record, please?
Tara Kellogg.
Thank you. Counselor, your appearance?
Christopher Reed, 6791, on behalf of Ms. Kellogg.
And bundled or unbundled, Mr. Reed?
I am bundled.
Okay. And then, Mr. Ghibaudo, your name for the record?
Alex Ghibaudo.
Thank you. So now I'm going to both of you sworn in by the court clerk.
Raise your right hands, please. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. So, Mr. Ghibaudo, I did see you have counsel in the D case, but no counsel in this case, and no appearance has been made. So I'm going to go ahead and proceed. Do you know, did you expect an attorney to be present with you on this case today?
Trying to get my counsel, Radford Smith, to appear, but it's been a little bit challenging
Okay.
with schedules.
Okay. All right. So I'm going to go ahead and proceed. So also in this courtroom is the district attorney. I'm going to start by hearing from the district attorney and then hear from everybody else. All right, Mr. DA.
Thank you, Your Honor. This is the DA's office motion to suspend the respondent's law license due to his failure to pay child support in this case. The parties were divorced on February 1st, 2017 in District Court Case D-15-522043D. The decree of divorce required the respondent to pay $819 per month in child support for the party's child, Nicole. Nicole has emancipated, but this case is still being enforced at $819 per month until the child support arrears are satisfied. Unfortunately, the respondent has not made timely child support payments in this case, and there are arrears in the amount of $8,388.70. As this court's aware, NRS 425 sub 540 and 560 permits this court to enter a master's recommendation which determines that a person who is issued a professional license is in arrears in the payment of child support, and it also permits the court to suspend that person's professional license. The respondent in this case is a licensed attorney practicing under bar number 10592. The respondent has failed to pay child support as of order, and as I mentioned before, owes arrears in the amount of $8,388.70. To review the respondent's payments, in the year 2018 there were no child support payments reported. In 2019 there were two payments, one May 17, 2019, one December 13, 2019. In year 2020 there have been two payments, February 18, 2020 and April 17, 2020. So as this court can see, the respondent's not making those monthly payments of $819 per month. So therefore, the DA's office has filed this motion. The DA's office is requesting the court to enter a recommendation for the respondent's law license to be suspended until the respondent satisfies the child support arrears pursuant to NRS 425.560.
All right, so I'm making some findings while everybody's going along, and everybody will get copies of this MROJ in the mail later. All right, so, Mr. Ghibaudo, there's no opposition filed to this motion, so I'm inclined to treat it under the EDCR as not opposed. Why didn't you file an opposition or something?
It's like I said, Your Honor, I was trying to get my attorney involved. We all have very busy schedules. We're all preparing for trial. I asked for a continuance before. The court denied it. I'm willing to make an argument. If the court allows it,
Well, no.
a little argument. It's really easy. This is a simple case, Your Honor. First, I require a trial. I am objecting to this happening over the phone. I need to be able to present evidence. Because what the DA just said is apparently untrue. He's saying that I haven't paid child support since 2018. That's absurd. If I hadn't paid child support since 2018, I would have far more than $8,000. The fact is that I paid $2,500. In 2018, I paid $2,500 every single month.
So the bottom line,
Which means that I paid $30,000 for that whole year.
Mr.
Portion
Ghibaudo.
of that goes towards child support.
So, Mr. Ghibaudo, the fact that you did not file an opposition because you were too busy to file an opposition is not a defense, obviously. And again, the EDCRs were pretty clear. I'm supposed to treat these motions as meritorious if they're not opposed.
Well, look, Your Honor, this is a punitive action here. What the DA is asking you to do is take my license away. That's a sanction. I require a trial with a lawyer present.
Well,
If I don't have a trial with a lawyer present on a criminal contempt where you're sanctioning me, this is just going to end up in an objection before the court.
So, Mr.
This is
Ghibaudo,
absurd. This is a
again,
violation of my due process rights. You're giving that woman exactly what she's been dying for 4 years, to take my license.
Okay.
By the way, Mr. DA, you already talked to Phil Patty at the bar. He already told you can't do this.
okay,
The
Mr.
Supreme
Ghibaudo,
Court takes my
do not
license,
address-
not this court,
Mr.
not the DA's
Ghibaudo,
office.
do not address the district attorney. You're here to testify to me. Thank you.
Well, I'll tell you, Your Honor, that he called the state bar, talked to Phil Patty, and Phil told him he can't do this. I'm not governed by NRS.
Okay.
The statute that he's citing doesn't fall. I don't fall under that. I fall under the Supreme Court rules. So that motion should be denied because it's frivolous.
Again, all of these would have been good things to put in writing. So at this point, though, substantively, I don't have much to go on since you didn't oppose it.
Well, you know the rules better than I do, Your Honor.
Okay. So the bottom line is, now, Mr. DA, and then I'll hear from Mr. Reed in terms of his position on this motion as well. It's about the finding of simply $1,000, greater than $1,000 being owed. It's not so much the payment history, but that arrears are owed. Is
Yes,
that
sir.
your argument
Yes.
under the statute? All right. Mr. Reed, you didn't file anything either in regards to Mr. DA's motion, but did you have something you wanted me to know?
No, I appreciate that, Your Honor. Obviously, from Ms. Kellogg's perspective, all she wants is compliance. That's the whole nature of the motion. That's the nature of the DA. To the extent that we'll just make a joinder to that, we just want compliance.
Okay.
No, she wants to take my license. That's why they're joining it. She doesn't want to comply. She doesn't care. She gets paid. She has money. And my daughter's never lived with her. She just wants my license. That's demonstrated by the fact that every one that she's had, except this one that I know of, it's all the bar complaint against me asking for the court to take my license. Now I ask the court, how am I supposed to pay $8,000 when I don't have a law license anymore? Do you really do that? Because I don't know how I'm going to do it.
Okay, let me make my findings. So on the audit itself, let me start with you, Mr. Ghibaudo. A copy of the audit was sent to you in this motion, $8,388.70. In terms of the audit itself, what did you want me to know about it?
Well, that audit's fine, but it can't be the case what the DA said that I haven't paid since 2018. It's that, I'm fine with that audit, and I intend to pay it.
Okay.
But I'm waiting for the trial that's next month.
Okay, all right. Testifying. And Mr.
Because I'm
Reed?
challenging the order, Your Honor. You don't understand. I'm challenging the order as void,
Okay.
as entered. That's the nature of the challenge. That's what my attorney has challenged, and that's what's on for trial.
And Mr. Reed, did you receive the audit as well in the motion? Any comments or issue with the audit today?
No, Your Honor. In fact, the audit is consistent with the audit we discussed at the last hearing. We've adequately discussed before this court that certain family support obligations have been backed out because they're no longer enforced by the district attorney's office. We understand that. This is the same audit we've discussed previously and submitted on that.
Okay. All right, so with that makes it easy. I will go ahead and reduce these arrears to a judgment. So back to the statute itself in terms of under the motion itself, let me see. We got NRS 425560. It just simply requires a finding of owes arrears of more than $1,000.
Your Honor, if I may, I believe it's 425.540 and 560. And in 540, it's sub 1, sub B, and it's just is a finding that is in arrears in the payment for the support of one or more children. It's very similar to 560.
Got it, thank you. Still looking at the statute, just getting my language correct.
I'm sorry, Your Honor, I did not hear you.
I'm just, the silence is simply me looking at the statute, trying to get the language correct in my recommendations. All right. So here are my findings, that first off, procedurally, based on the EDCRs, the motion should be granted as unopposed and therefore meritorious, and that the respondent has consented to the motion. And then substantively, I went on and said that on the merits, the court finds that the respondent owes the child support arrears for the minor child Nicole, or for the child, I know she's emancipated, for the emancipated. Nicole, and that those arrears are in excess of $1,000. The court further finds respondent is delinquent of not less than 2 months in payments and for the support of Nicole as ordered by the court. Based on these findings, the court recommends, and then I've typed the same language right out of the statute about the letter being sent, the state bar, the 30 days notice, otherwise automatic suspension of the license. So with all of that, I am going to grant the motion. The district attorney's notice of motion to suspend Mr. Ghibaudo's license to practice law in the state of Nevada is granted. So I'm going to take this motion off calendar. I can't remember if there's already a future date on the contempt. I've lost track. Is there a date? No. I'll just take the whole thing off calendar.
So this court, I'm sorry, Your Honor, you put in your order that I conceded that this is a meritorious motion?
No, I did not say that. I just quoted this EDCR that says because you did not file a written opposition, I should treat it as meritorious and as you having consented. It's the language right out of the EDCR.
I understand the language, Your Honor, but here I am telling you that the motion is without merit.
Mr.
Where
Ghibaudo,
in that statute that's cited?
Mr. Ghibaudo,
Where in that statute that's cited does
I've
it
made my
say?
recommendations. I'm going to sign this, and copies will be mailed to everyone. Thank you very much,
So
everybody.
the
We're all
idea
done.
is I get my license suspended
We're done,
so
Mr.
that she
Ghibaudo.
gets paid. How am I supposed to do that?
Goodbye,
Can you
guys.
explain to me